In Western Land Equities Incorporated versus City of Logan, we'll see what happened when a city changed the permitted zoning uses for a plot of land after a developer submitted an application to build a subdivision. Western Land Equities purchased over 18 acres of land in Logan, Utah. In 1976, the property was zoned as M1 under the city's new land use ordinance. Single-family houses were permitted in M1 zones. In July of 1977, Western Land submitted a plan to the city's planning commission to build a subdivision of single-family homes on its 18-acre plot. In November, the planning commission rejected Western Land's proposed subdivision because the property was contrary to the city's master plan, the access roads in and out of the subdivision weren't adequate to support fire services, and the plan didn't have adequate sidewalks. In January of 1978, the city amended its zoning ordinance to prohibit single-family houses in M1 zones. Western Land sued the city and sought a declaration that Western Land had a vested right to develop the subdivision. Western Land also wanted to stop the city from withholding approval of the subdivision. The trial court held that Western Land had a vested right to develop its property because Western Land's proposed subdivision was permissible before the city amended the zoning ordinance in 1978. Western Land also complied with the city's procedural requirements. The court held that the city was stopped from withholding approval of the subdivision. The city appealed and argued that a permit application for a subdivision doesn't create a vested right that would make Western Land immune from subsequent zoning changes.